Hi there, Steph here from Youth Law, answering some of your questions that we didn't get to from the young people and renting session. So I'll just start by reading out the question and kind of giving my answer. So the first question is, are TAP services just for private rentals? Specifically, what is the service for social housing tenants? So it's correct that TAP services are just for private rentals. For social housing tenants, they can access support through the Tenancy Plus support program or through contacting Tenants Victoria. The next question is, for young people under the age of 18 who need to look at the rental market due to lack of other options, we know they often experience bias and discrimination in being able to get on a lease. What's the best way to advocate for them to be put on a lease by a landlord or real estate agent? I think it's important to explain that young people under the age of 18 can enter into an agreement on contract if it's for a necessary service, and housing is a necessary service. The rights and responsibilities of both parties are the same under the Residential Tenancies Act, regardless of the age of the renter. So that might be able to alleviate some concern in having a young renter. Also, just by practically asking what are the concerns and what can be done to alleviate those concerns. Is it that they're worried there might be damage to the premises? Can we provide some references or character supporting material for that young person, about what's going on for them and how there's kind of no need to worry? Or are they concerned about finances? Let's just get their proof of income, their pay slips ready to go so we can alleviate any of those concerns. The next question is, does accessing the rental dispute resolution service impact a young person's rental history? The short answer is no, it shouldn't. Tenants or renters can only be entered onto a tenancy database if they owe a greater amount than the bond during or at the end of their tenancy, or VCAT has made a possession order in relation to a previous tenancy. So no, accessing RDRV is not going to come up on any kind of tenancy databases. However, the impact that you might see is that if they have accessed RDRV and they provide the agent's details as a reference for a future rental, it's really hard to just determine what information is going to be passed on from that previous agent onto the new one. So although it shouldn't, it could still have some kind of impact. The next question is, what happens if a notice to vacate for the end of a fixed term lease is issued less than 90 days before the end of the lease? So if you look at section 91ZZD of the Residential Tenancies Act, it states that for notice for the end of initial fixed term, it needs to be not less than 90 days before the end of that fixed term. So if it's less than 90 days, then I would argue that that notice to vacate is invalid. The next question is regarding social housing. Is there a formal approach to notice periods related to rebated rent? When I've previously worked in social housing management, rebated rents could be altered with little formal notice, whereas market rents require a formal notice period. Rental rebates for social and community housing have been specifically legislated to be held outside of the Residential Tenancies Act, and that's under section 44, subsection 4B of the RTA. So there's no formal notice periods as is required for other notices of rent increase under the RTA. However, there is the rent setting and rebate operational guidelines that is set by the Department of Families, Fairness and Housing, which indicate when rent reviews can occur. These can be at shorter periods, for example, every 6 months, or when there's been a change in a renter's circumstances. That's definitely different to the 12 monthly increases under the RTA, but it is important that social and community housing renters are aware of those guidelines, as well as any other guidelines that might be available on their community housing provider's webpage. So although it's not covered under the RTA, there should be processes that still need to be used when calculating rebated rent. The next question is, do you have any tips or advice in regard to building positive relationships with local real estate agents and property managers? I mean, this is a tricky one. I think meet with them if you can. If it's in your capacity as your role as a worker, offer to assist at any issues that might come up in a tenancy if you're working with a lot of young people in the area. What are the issues that they might see when renting to young people, and how as a worker can you support young people in staying in their housing? I think, unfortunately, as a lawyer, I see the pointy end of most of these relationships, but I'm sure if you can have some discussions, it might be helpful for the young renters in your area. The next question is, I would love to know if you have any advice for lease transfers. We often see these offered on various community pages. It can be a good resource to lean on, but in my experience as a worker, it can be challenging to navigate, particularly when an existing tenant has not yet disclosed to the landlord/agent. How can we support young people to protect themselves with lease transfers? What is important to know? I think it's important to know that the rental provider is not allowed to reasonably withhold their consent for a lease transfer under Section 81 of the Residential Tenancies Act. And if the rental provider does unreasonably withhold their consent, you can apply to VCAT for an order for the transfer to go ahead without that consent. Usually in the first instance, I always tell young people to try and get consent of the rental provider, because if they don't get consent, the rental provider could issue a 14 days notice to vacate to that renter. So get that consent first. If they don't give you consent, then apply to VCAT for the transfer to occur without that consent. The other thing to be careful of in lease transfers is that the bond is changed into their name for an incoming tenant with the residential bond authority. So make sure they get a new bond receipt from the RTBA with their name on it. Also, to make sure they inspect the property carefully, because if they're coming into a lease and they are one of the renters that's left on the lease when the lease ends, they could be up for large damage claims against their bond if they haven't inspected it properly. Something to think about if you're leaving a share house in a lease transfer is to only leave once the incoming tenant has paid you the bond. That's just a way to protect you from being owed money in relation to that bond, because it will be really hard to get it at the end of the tenancy if you're no longer there. The next question is, and last question is, would you consider the fees for VCAT services a barrier to young people asserting their legal rights with respect to renting? I think this is a really great question, because now the RDRV process is free. So any renter can access RDRV and not have to pay any kind of fee. If the case is not kind of resolved at RDRV and it needs to go to VCAT, there are generally no fees in relation to bond disputes. And if the young person holds a healthcare card, they can have fees waived for most other claims. So there might be fees if the case is at VCAT and it goes for a hearing that lasts more than a day, or a more kind of legal documents need to be obtained through subpoenas. There might be some fees. I think, however, generally in a standard rental dispute, there are little to no fees. for young people, especially if they hold a healthcare card, and that the VCAT jurisdiction is definitely more accessible than most others. So, yeah, I think it's not necessarily a huge barrier. I hope that's answered most of your questions. And thanks for having me, and VCOSS too. And we'll talk to you again soon.